Summoning means when he calls upon the members of the parliament to gather and begin legislative business. Prorogue means you end a session. Dissolution is possible only with respect to the directly elected chamber, because the Council of States is a permanent chamber. So the popular chamber or the Lok Sabha is only subject to dissolution. The veto powers of the Indian president is a combination of absolute veto, suspensive veto, and pocket veto. Qualified veto, which rests with the American president, is not available to the Indian president. So let's have a look. The powers and functions of President of India is a broad set of powers. Executive powers, legislative powers, judicial powers, all of them. Administrative powers, military powers, financial powers. So let's have a look at all these powers. We'll start with the executive powers. All executive actions of the government of India are formally taken in his name. I told you that, in fact, the only way to ascertain that whether an action is or an order is passed by the government of India is to check that whether it has been promulgated in the name of the President of India. If it has been, then you can say that is the government of India order. He can make rules specifying the manner in which the orders and instruments made and executed in his name shall be authenticated. Now, you might have seen that many times the orders which are passed by the government of India, the notifications which are made by the government of India, it would read that His Excellency President of India. It means how the president would be addressed. It is decided by the president. In fact, Mr. Pranab Mukherjee, when he was the president, he said that the epithet of His Excellency shall be replaced with Most Honorable. So that is what was done during the time of his presidency. He can make rules for more convenient transaction of business of the union government and for allocation of the said business among the ministers. He appoints the Prime Minister and other ministers. They hold office during his pleasure. In fact, the pleasure of the President is actually the pleasure of the Prime Minister. He appoints the Prime Minister and other ministers on the advice of the Prime Minister. He appoints the Attorney General of India and determines his remuneration. In fact, the Attorney General of India holds office at the pleasure of the President. He appoints the Comptroller and Auditor General of India, the Chief Election Commissioner and other election commissioners, the Chairman and members of the Union Public Service Commission, the Governors of State, the Chairman and members of Finance Commission, and so on. But not all these members hold office at the pleasure of the President, save perhaps the Governor of the State. The Governor of the State holds office at the pleasure of the Union Executive, rather. So you see that he can seek any information relating to the administration of the affairs of the Union and proposals for legislation from the Prime Minister. In fact, the Prime Minister acts as a link between the Union Council of Ministry and the President of India. He can require the Prime Minister to submit for consideration of the Council of Ministers any matter on which a decision has been taken by a minister but which has not been considered by the Council. Now, this clause has been incorporated to ensure the unity of the Council of Ministers. Suppose some minister has given some advice to the President, but that advice has not been discussed or deliberated in the Council of Ministry, then the President can cause that advice through the Prime Minister to be laid before the Council of Ministry for its consideration. Anyhow, he can appoint commission to investigate into conditions of scheduled castes, scheduled tribes and other backward classes. He can appoint an interstate council to promote center-state and interstate cooperation. He directly administered the union territories through administrators appointed by him. He can declare any areas as scheduled area and has powers with respect to administration of scheduled areas and tribal areas. So these are some special executive responsibilities that are given to the President. Let's have a look at the legislative powers of the President. The President is an integral part of the Union legislature. In fact, the Parliament comprises of the President, the Lok Sabha and the Rajya Sabha. He can summon or prorogue the Parliament and dissolve the popular chamber. Summoning means when he calls upon the members of the Parliament to gather and begin legislative business. Prorogue means you end a session. Dissolution is possible only with respect to the directly elected chamber, because the Council of States is a permanent chamber. So the popular chamber or the Lok Sabha is only subject to dissolution. Now, look here, that adjournment is done by the presiding officer of the House, but summoning, prorogation and dissolution of the popular chamber is exclusive power of the President of India. He can also summon a joint sitting of both the houses of the Parliament in case of a deadlock situation, and in fact he directs that it is the Speaker of the Lok Sabha who would preside over such joint sitting. But remember one thing, such joint sitting is not possible with respect to money bill, and secondly it is not possible with respect to constitutional amendment bill. Anyhow, he can address the Parliament at the commencement of the first session and after each general election and the first session of every year. So once a fresh Parliament gathers, the President comes and addresses both the houses of the Parliament collected together at one place, or the President also have the right to address the first sitting of the first session of every year, both the houses. Apart from this, the President also has the right to send messages to the Parliament with respect to legislative business or otherwise. The President can also address both the houses individually or collected together at any other time as well. So you see, he can send messages to the houses of Parliament, whether with respect to bill pending in the Parliament or otherwise. He can appoint any member of the Lok Sabha to preside over its proceedings when the offices of both the Speaker and Deputy Speaker fall vacant. Similarly, he can also appoint any member of the Rajya Sabha to preside over its proceedings when the office of both the Chairman and the Deputy Chairman fall vacant. He nominates 12 members of the Rajya Sabha from amongst persons having special knowledge or practical experience in literature, science, art and social service. This is the nomination element in the Rajya Sabha. He can nominate 2 members of the Lok Sabha from the Anglo-Indian community. And why I am showing this in red ink? Because this has been abolished by the 104th Constitutional Amendment or the 126th Constitutional Amendment Bill. Now, these 2 members from the Anglo-Indian community, which were otherwise going to the Lok Sabha, and 1 member who was going to the state legislatures through nomination by the President and the Governor, as the case might be, no longer exists. He decides on questions as to disqualifications of members of the Parliament in consultation with the Election Commission. His prior recommendation or permission is needed to introduce certain types of bill to the Parliament. For example, a bill involving expenditure from the Consolidated Fund of India, a bill for the alteration of boundaries of states or creation of a new state. Remember, Article 3, if you need to introduce a bill, you have to obtain the recommendation of the President. Now, when a bill is sent to the President after it has been passed by the Parliament, he has the following options, but all options are not open with respect to all the bills. But for ordinary bills, all options are open. And what are they? Give his assent to the bill. The moment he gives his assent to the bill, it becomes a law. Withhold his assent to the bill, which is absolute veto. Return the bill if the bill is not a money bill for the reconsideration of the Parliament. However, if the bill is reconsidered by both the houses of the Parliament and is returned back to the President with or without amendment, then the President shall give his assent, provided that the bill is not a money bill, because money bill cannot be returned. When a bill passed by the state legislature is reserved by the Governor for the consideration of the President can. Now, what happens when a bill is presented to the Governor? He can also declare his assent. He can declare that he withholds his assent. He can return the bill, provided the bill is not a money bill, to the state legislature for his consideration. Or there is a 4th option, he can reserve the bill for the consideration of the President. This option is very much modeled on the Government of India Act 1935, where the Governor could reserve the bill for the consideration of the Crown. So this is something like that. And when whether the bill should be reserved or not, it's a discretionary power of the government. But in one case, it's an obligatory situation when the bill in question is derogating the powers of the High Court of the state concerned. Then it needs to be reserved for the President. Once the bill is reserved for the President, then it becomes a business between the state legislature and the President of India, and the Governor goes out of picture. So suppose if it is reserved for the President by the Governor, and reservation, the decision is a discretionary power of the Governor, then the President can give his assent to the bill, then it becomes a law. He may declare that he withholds his assent to the bill, then it's veto. Direct the Governor to return the bill if it is not a money bill for the reconsideration of the state legislature. It should be noted that it is not obligatory for the President if the bill makes a second journey from the state legislature to the President for obtaining his signature. In case of union law, it is a compulsion, whereas in case of bills, state bills which are reserved for the consideration of the president, it is totally at the mercy of the union executive. And that's why several constitutional experts say that Indian constitution is quasi-federal, because there is a central control over the state legislature. Well, you see that state politics often functions on narrow considerations. Say, for example, some special that they're saying that we renounce the practice of a particular language, which is the official language of India. Therefore, to prevent such kind of mishaps, this power has been conferred to the union executive through the president. He can promulgate ordinances when the parliament is not in session. For passing a bill, both the houses of the parliament must be in session. If either of the houses are not in session, he can promulgate an ordinance. Ordinance has the same effect as that of a law. We'll look at ordinance in some detail in some time. These ordinances must be approved by the parliament within 6 weeks from its reassembly. It means these are temporary legislations which are made by the executive. He can also withdraw an ordinance at any time. He lays the reports of the Comptroller and Auditor General, the UPSC, Finance Commission and others before the Parliament for its consideration. He can make regulations for the peace, progress and good government of Andaman and Nicobar Islands, Lakshadweep, Dadra and Nagar Haveli, Daman and Diu and Ladakh. In the case of Puducherry also, the President can legislate by making regulations, but only when the assembly is suspended or dissolved. So, you see that there are some special legislative powers which are there with respect to the President's office. We'll look at them in more detail in some time, but I'm now just introducing them. The financial powers, money bills can be introduced in the Parliament only with the prior recommendation of the President. That's why money bills cannot be returned by the President to the Parliament. He causes to be laid before the Parliament the annual financial statement and supplementary financial statements, if any, which is the union budget. No demand for grant can be made except on the basis of the recommendation obtained from the President. Demand for grants, they are the demands which are made under the annual financial statement on revenue and expenditure. In fact, these demands of grants are then voted by the Lok Sabha and they're clubbed with the charged expenditure and made into a appropriation bill, which is then passed like a money bill in the union legislature. He can make advances out of the contingency fund of India to meet any unforeseen expenditure. He constitutes a finance commission every 5 years to recommend the distribution of revenues between the center and the states. Judicial powers. The judicial powers of the function of the President is he appoints the Chief Justice and the judges of the Supreme Court and High Court. But here you know that there is this collegium angle which we should not forget, because independence of the judiciary is a part of the basic structure of Indian Constitution. He can seek advice from the Supreme Court on any question of law or fact, which is nothing but the advisory jurisdiction of the Supreme Court. However, keep this in mind that the advice which is tendered by the Supreme Court of India is not binding upon the President of India. Anyhow, he can grant pardon, reprieve, respite, remission of punishment or suspend, remit or commute the sentence of any person convicted of any offense which results from the violation of any union law, or if it is a court-martial, or if it is a sentence of death. Keep this in mind. Court-martial and death sentences can be commuted or pardoned rather only by the President. They cannot be done by the governor. Diplomatic powers. The international treaties and agreements are negotiated and concluded on behalf of the President. In fact, even if the Prime Minister visits somewhere, the papers, they are signed all in the name of the President. However, they are subject to the approval of the Parliament. He represents India in international forums and affairs and sends and receives diplomats like ambassadors, high commissioners and so on. He is the representative of India and also the host as well as far as the foreign diplomats are concerned. Military powers. He is the commander-in-chief. You know that he is the supreme leader or commander of the defense forces of India. In that capacity, he appoints the chiefs of the army, the navy and the air force. He can declare war or conclude peace subject to the approval of the Parliament. It means there is not an unbridled power which is conferred or vested in the President, but it is subject to some legislative control. The emergency powers, it means the power to declare national emergency, constitutional emergency, financial emergency, all rests with the President of India. Let us now have a look at the veto powers of the President of India in some more detail. Now, I told you that a bill by the Parliament can become an act only if it receives the assent of the President. When such a bill is presented to the President for his assent, he has three alternatives. This is only with respect to ordinary bills. He may give his assent to the bill, he may withhold his assent to the bill, he may return the bill if it is not a money bill for the reconsideration of the Parliament. However, if the bill is passed again by the Parliament with or without amendments and again presented to the President must give his assent. Now, thus the President has the veto power over the bills passed by the Parliament, that is, he can withhold his assent to the bill. The objective of conferring this veto powers on the President is to prevent hasty or ill-considered legislation or to prevent unconstitutional laws. Do you understand this? This is what is the nature of the veto powers. The veto powers of the Indian President is a combination of absolute veto, suspensive veto and pocket veto. Qualified veto, which rests with the American President, is not available to the Indian President. So let's have a look at absolute veto. Absolute veto means when the President declares that he withholds his assent to the bill. That can be done with respect to ordinary bills or money bills. So it refers to the power of President to withhold his assent to the bill passed by the Parliament. The bill then ends and does not become an act. Usually this veto is exercised in the following two cases. First, with respect to a private member's bill. Who is a private member? Any member of the legislature who is not a minister is a private member. It means who is not a part of the Council of Ministry. He can be from the ruling party as well, but still he would be treated as a private member. That is, bills introduced by any member of the Parliament who is not a minister. And with respect to government bills, when the cabinet resigns, suppose it is a government bill, it means introduced by a minister. But before the bill can make the journey in both the houses, and by the time it reaches the President, the Council of Ministers has lost support and a new Council of Ministers have emerged in its place, and it advises the President to declare his veto to the bill. And thus, the President shall be constitutionally under the obligation to follow the advice of the new Council of Ministry. So, a government bill can also be vetoed. Suspensive veto. This is not available with respect to money bill. The President exercises this veto when he returns the bill for reconsideration of the Parliament. However, if the bill is passed again by the Parliament with or without amendments and again presented to the President, it is obligatory for the President to give his assent to the bill. This means that the presidential veto is overridden by a repassage of the bill by simple ordinary majority. When it is by extraordinary majority, that is qualified veto, which is not available to the Indian President. President does not possess this veto in case of money bills. Money bills cannot be returned back. The President can either give his assent to a money bill or withhold his assent. It means absolute veto kar sakte ho, but suspensive veto nahi kar sakte aap to a money bill. But bill cannot be returned for the reconsideration of the Parliament. Now, what is pocket veto? The Constitution says that when a bill is presented to the President for his assent, he should declare his assent, he should declare that he has withhold his assent, or he may return the bill if it is not a money bill for the reconsideration of the Parliament with or without a message. But the Constitution does not highlight any time period within which the President should make any of these decisions. In fact, this is what has been construed by some of the legal luminaries, that this is a veto which is given to the President. It's a pocket veto where the President just make the bill lie on his table indefinitely without making up his mind. This is often done by the President when he finds that the Council of Ministers is shaky and it can lose support in the Union legislature any day. Under such circumstances, you would see that the President will resort to this veto powers. In fact, under the American Constitution, the American President, it is binding on him that he must return the bill if he wants to within 10 days. So, if suppose he makes it lie for the 10 days, so he can hold it for 10 days without expressing his mind. So, the veto extends for 10 days. He can pocket it for 10 days. That's why it's said that because no time limit has been mentioned in the Indian Constitution, the pocket of the Indian President is bigger than that of the American President. Let's have a look at this. In this case, the President neither ratifies nor rejects nor returns the bill, but simply keeps the bill pending for an indefinite period. This power of the President not to take action, either positive or negative, on the bills is known as the pocket veto. The President can exercise this veto power as the Constitution does not prescribe any time limit within which he has to take the decision with respect to a bill presented to him for his assent. In USA, on the other hand, the President has to return the bill for reconsideration within 10 days. Hence, it is remarked that the pocket of the Indian President is bigger than that of the American President. The 24th Constitutional Amendment has made it mandatory that when it is a Constitutional Amendment bill which is presented to the President for his signification, it is mandatory on the President to give his assent. It means he cannot declare that he withholds his assent. There is no question of returning the bill for reconsideration. So it should be noted that here the President has no veto power in respect to Constitutional Amendment Bill. The 24th Constitutional Amendment Act of 1971 made it obligatory for the President to give his assent to a constitutional amendment